The Arctic Sunrise Arbitration and Acts of Protest at Sea. The present article analyzes the Arctic Sunrise Arbitration, which concerns the lawfulness of the boarding and seizure of the Dutch-flagged vessel Arctic Sunrise during a protest against the oil rig in the exclusive economic zone of the Russian Federation. Even though the Arctic Sunrise vessel was 3 nautical miles from the rig, the Greenpeace activists on board were arrested, detained and charged with piracy, which was later replaced with a charge of aggravated hooliganism. Peaceful protest at sea is an internationally recognized lawful use of the sea related to the freedom of navigation, and it is therefore subject to the limitation defined by, inter alia, the law of the sea. This necessitates a balancing of the right to protest at sea with other legitimate interests, including safety of navigation and the safety and security of artificial island installation and structures located on the continental shelf or in the exclusive economic zone of a state. According to the award, the coastal state should tolerate some level of nuisance caused by civilian protests as long as it doesn't amount to an interference with the exercise of its sovereign rights. In order to protect its sovereign rights, a coastal state may respond appropriately against acts of protest provided such measures are reasonable, necessary, and proportionate. The Arctic Sunrise case raises a number of interesting legal questions concerning the phenomenon of act of protest at sea, questions that haven't been adequately explored to date. This paper aims to analyze the difference between act of protest at sea, piracy and maritime terrorism, the limit on the right to protest at sea, and the connection between the law of the sea and the protection of human rights. On the morning of 18 September 2013, 2 Greenpeace activists attempted to scale the Gazprom-operated Prirail-Zomnia oil platform located in the Exclusive Economic Zone or EEZ of the Russian Federation. This act was intended to be a non-violent direct action protesting the platform's oil drilling activities. The next day, in response to the protests, the Russian authorities boarded and seized the Arctic Sunrise, a Dutch-flagged Greenpeace vessel. The Arctic Sunrise was towed to the Russian port of Murmansk and was subsequently seized by the Leninsky District Court. Russian authorities arrested and detained the Greenpeace activists on board the Arctic 30, charging them with piracy. 1 month later, the authorities dropped the piracy charge against the Arctic 30, replacing it with a charge of aggravated hooliganism. Piracy consists of acts of violence or depredation committed for private ends of the high seas from person on board a ship against another ship. The fact that the Prirail-Zomnia is not a ship was the reason for the alternate charge of hooliganism against the Arctic 30. The initial charge of piracy, however, allowed the Russian authorities to board the Arctic Sunrise as provided by Article 105 of the United Nations Convention on the Law of the Sea or UNCLOS and according to the principle of universal jurisdiction to arrest and charge the Arctic 30. On 4 October 2013, the Kingdom of the Netherlands instituted arbitral proceedings against the Russian Federation under Annex 7 to the UNCLOS. On 22 November 2013, pending the constitution of the Arbitral Tribunal, the International Tribunal for the Law of the Sea or ITLOS ordered the Russian Federation to release the Arctic Sunrise and its crew upon payment of €3.6 million. Russia didn't participate in the proceeding at any stage, invoking the declaration that it made when becoming a party to the UNCLOS, according to which it doesn't accept procedures provided for in Section 2 of Part 15 of the Convention, entailing binding decision with respect to dispute concerning law enforcement activities in regard to the exercise of sovereign right or jurisdiction. Prior to discussing the merit of the claim by the Netherlands, the tribunal addressed issues of jurisdiction and admissibility, concluding that Russia's declaration didn't exclude prima facie the dispute from the jurisdiction of the tribunal. According to Article 298, Part 1b UNCLOS, the optional exemption in connection with dispute concerning law enforcement measures in regard to the exercise of sovereign right or jurisdiction only applies with respect to dispute concerning marine scientific research and fisheries, neither of which was at issue in the Arctic Sunrise case. Russia's non-appearance didn't constitute a bar to proceeding by virtue of Article 9 of Annex 7 to the UNCLOS, according to which the tribunal can make its award if the other party to the dispute requests the tribunal to continue the proceedings. The tribunal made its award on 14 August 2015, declaring that the boarding and seizure of the Arctic Sunrise by the Russian Federation and the arrest of the Arctic 30 was illegal. Consequently, it ordered the Russian Federation to compensate the Netherlands for the damage caused to the Arctic Sunrise and its crew. The tribunal didn't discuss the direct action put in place by the two activists who had tried to climb the platform and their subsequent arrest by the Russian authorities because the Netherlands statement of the claim focused on the legitimacy of the boarding. This paper aimed to analyze the legal aspect of the Arctic Sunrise case concerning the law of the sea and the international protection of human rights. In particular, it will explore the difference between acts of protest at sea and piracy on the one hand and maritime terrorism on the other. Finally, this paper aims to examine the limit of the right to peaceful protest at sea and the human rights standard applicable to maritime law enforcement measures intended to prevent and punish violent acts of protest. The Association of Protests at Sea with Illicit Act. The Russian Federation put forth a number of legal justifications for the measures taken against the Arctic Sunrise. The legal issue of the exercise of enforcement jurisdiction over the vessel and the activists was resolved by the fact that the Greenpeace activists were initially accused of piracy ex Article 101 UNCLOS. According to the general norm of international law codified in Article 105 UNCLOS, every state may seize a pirate ship and arrest the person on board on the high seas and, in conjunction with Article 58.2 UNCLOS, in the exclusive economic zone. However, relying on a chart of piracy raised a number of different problems, which we discuss in the following. The Russian authorities accused the crew of the Arctic Sunrise of maritime terrorism as provided by the 1988 Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation and the 1988 Protocol for the Suppression of Unlawful Acts Against the Safety of Fixed Platform located on the continental shelf together, 1988 SUA Convention and its Protocol, to which the Netherlands and the Russian Federation are both parties. The 1988 SUA Convention and its protocol were amended in 2005, but unlike the Netherlands, the Russian Federation didn't ratify them. Thereafter, the Russian Federation, in a diplomatic note of 1 October 2013, accused the Greenpeace activists of infringing laws applicable to artificial island installation structures and the surrounding safety zone in the EEZ covered by Articles 56 and 60 UNCLOS. Thank you.